Firstly, Ms. Lehman, you mentioned there were 23 jurisdictions that had passed statewide laws that just diluted the vote since the Shelby decision. What do those 23 states have in common, if anything? Were they particularly a political party controlled the General Assembly? Were they of any particular section of the country? Can you give us a little definition or?
Well, the main commonality among those 23 states is their willingness to make voting more restrictive and to make it more challenging for their citizens, and that in itself is a concern. The reality is that these 23 jurisdictions are across the country and are not defined by particular party control. So
there were some states that had Democratic Party control in the House and Senate, both that passed these restrictions?
I believe so. We can go back and give you that information with specificity. But the main concern is the electorate's decision in those states to make voting more restrictive for those states. And that is a serious concern given the status of voting rights in this country as we documented it in this report, and given the history of this country and the degree to which those much more restrictive laws passed in a very, very short time period. So that's a new turn for us as a country, and it's fairly sweeping.
And the fact that we've gone from the more opprobrious pre-1965, how many seeds there are in a bottle or whatever, to more invidious types of discrimination, does that in any way diminish the need for Section 5 preclearance in the jurisdictions that have those type of voting limitations?
Absolutely not, Chair. I am astonished by what we saw around the country in the choices to denigrate voters' access and ability to vote on the basis of race, on the basis of disability status, on the basis of language access. There are an astonishing variety of ways that our electorates have chosen to make it more difficult for some among us to vote.
Mr. Science, let me ask you this. In California, you now have redistricting of the state legislatures, not of the county governing bodies, and those are the ones you specifically, I think, referenced in your testimony. Are they also mandated to take into consideration racial minority districts to try to create those in their redistricting when they're done by court order?
They're all covered by Section 2, which of course means if they have a pattern of racially polarized voting and the rest of the Senate factors, the totality of the circumstances indicate that there is vote dilution occurring, then they are mandated to create a Latino majority district in the context of racially polarized voting and the geographic concentration of Latino voters such that you can create a district that is compact, contiguous, meets all the usual criteria. And I can assure you that every one of those counties has legal advice about specifically the issues under Section 2 of the Voting Rights Act. I think in many cases they are in essence gambling, assuming that because of the expense and the time involved in a Section 2 challenge, they won't be the jurisdiction that's challenged. And as I indicated, in the course of this decade, 8 of those 9 counties that we identified as potentially violating Section 2, essentially their gamble has paid off so far because they have not been targeted for litigation. Now, Kern County, which was challenged by MALDEF, after very lengthy litigation and trial, it did result in liability finding against them at great cost, and that I think is something that's not often remarked about. The cost to the defendant jurisdictions under Section 2 litigation is substantial. If they were subject to Section 5 preclearance, their costs would be minimal in comparison. The Kern County Board of Supervisors ended up paying, it's a public number because it's a part of a settlement, $3 million to the plaintiffs for their attorneys' fees and expert costs. You can assume that they have equivalent and probably even higher costs of their own. They had to hire outside counsel, employ their own experts.
Let me ask you this. You think Section 5 is the most important section for enforcement?
Absolutely. And it permits efficient
Ms. Lehman,
and
do you agree with that?
I do. Its loss is very significant.
Mr. McCrary, can you tell us why Section 5 is so important and necessary, and while Section 2 exists for the country, Section 5 is important, the most essential part of the Civil Rights Act? Voting Rights Act, excuse me. Turn your mic.
With the way Section 5 operated before Shelby County, it gave quick decisions for jurisdictions about voting changes they were intending to make. And most of them were pre-cleared, and most of them within the 60-day clock that governs the operation of the pre-clearance review. It cost them practically nothing. Moreover, it served an educational function that the Congress recognized in 2005 and 2006 when it was building that voluminous record. There were some states covered by Section 5 that actually supported the extension of the pre-clearance process in 2005 and 2006, and that's part of the record before Congress. The reason was that it gave those states an opportunity to consider seriously the needs of minority voters, the views expressed by minority voters in the pre-clearance review, as well as the local jurisdictions' views, and to make better decisions about how to change the electoral process in those jurisdictions. But where jurisdictions were not so well intentioned, it was possible to object to those changes. And oftentimes, when federal courts were asked to address this question, they reached the same conclusions as the Department of Justice. It was efficient, it was educational, it stopped things in their tracks that were going to be problematic, but for the most part, it did not interfere with the electoral process in those jurisdictions that were covered by Section 5.
Thank you, sir. And I now recognize the ranking member for 5 minutes, Mr. Johnson.